second-degree murder conviction. We avoided the first-degree and second-degree murder convictions. He's been convicted of manslaughter, which makes him eligible to be transferred to juvenile court, which is what we're going to be pursuing. We benefit from the very extensive reports that were done in preparation for the reverse waiver hearing that we were denied. And so we have the psychologists, psychiatrists, reports. We have the recommendations from juvenile services as to where this young boy could go and be serviced, that he is amenable to treatment. And so we're confident, and Judge Schiffer is a good judge, and she's able to separate the wheat from the chaff. This is something that was brought on to this boy's doorstep. He wasn't out looking to cause any havoc. He wasn't looking to cause anybody any pain. So, and I think the judge has seen that throughout the trial. Now, maybe he didn't exercise the judgment that a grown up would have, that an adult would have. Maybe he shouldn't have had access to a gun. Unfortunately, that's almost becoming a fact of life, quite frankly. But there's nothing in his background to indicate that the offerings of the juvenile system would not be sufficient to deal with this. And so we're feeling pretty good, because the state was offering us a plea to second-degree murder, which is the intentional killing of an individual, but with no premeditation. First degree, of course, which is what they asked the jury for, which is an intentional killing of an individual where there is premeditation. And then voluntary manslaughter, which is what they found him guilty of, is where you intentionally kill someone, but there's some justification, mitigation, or excuse. And so when you take a look at that, the jury found that yes, he was somewhat justified. There was some mitigation. There was some justifiable excuse for what he did, but it did not rise to the level of total exoneration, total self-defense of himself or others. And so therefore they said, okay, well, we found that he did shoot and kill Mr. Reynolds. We found that it was intentional, but we also found that there was some justification for that. There was some excuse, some mitigation. And we know what it was. It was Mr. Reynolds coming across the street with a baseball bat and swinging it at one of the kids. So the bottom line is, we're not as happy as we would have been if he had not been found guilty of the voluntary manslaughter. We're elated that he was not found guilty of murder 1 or murder 2, and we're optimistic that when we come back and we put before the judge this 60-page report delving into his psychological mindset, into his background, into prospects for the future, if made the programs in juvenile are made available to him, that we will find ourselves quite pleased with the way the disposition unfolds whenever it is scheduled.
Mr. Brown, when does it officially go to juvenile for sentencing? What's the timeline for that?
That'll be when we come back for sentencing. We're going to be arguing that he should be this case should be sent to juvenile court to be dealt with. It will be up to the judge to make that decision. If she says yay, then it'll go to juvenile, and we'll go through the whole process of what the disposition is going to be, which I'm sure would involve, some further time away from home.
Have you talked to your clients?
Yes, I did. And I talked to him. I prepared him for this. I told him what the possibilities were, and then after we actually heard the verdict, I re-emphasized that listen, it's not too bad. We were able to ask the court to put this case in juvenile court, and except for all the brouhaha associated with this case, it is a good case to transfer to juvenile court because of his background, because this matter was brought to him. He didn't go looking for trouble. It was brought to him, and maybe he didn't act the way an adult would have acted, but he was 14 at the time. So we're pretty confident in our chances of having this transferred to juvenile court.
And you said that you're related. What did he have to say to you? What did he say to you after you said you're related, but what did he say to you?
Thank you.
That's it?
He said,
How much time do you get for manslaughter? Is it the same as juvenile?
It's a maximum of 10 years, but we're not looking at that kind of thing. And also keep in mind that he's been in the juvenile system for a year. They'll look at how he's done, even though it's over at YDC, which is still kind of a jail. but still they do offer some programming over there, and so they'll see how he's done over there, and I'm confident that we'll get good reports from that. And so it's that old adage, if it ain't broke, don't fix it. If he's already in the juvenile system, awaiting trial for a year, and he's done well over there, and he's taking advantage of the little courses that they have, then why not leave him on that track?
How soon does sentencing happen?
Probably, it could be, probably 30 days. Probably 30 days. I mean, we've got the reports, so there's no work need to be done on that. And so, probably 30 days. It doesn't have to be very long.
Mr. Brown, earlier this week you said you were ready to file an appeal if it didn't go your way.
Yeah.
What's the status of that? Was this your way?
It's definitely going to be an appeal, and there's some issues that occurred during the trial that will probably make their way into an appellate brief. But most potently is the denial of our request to have the case transferred to juvenile court some many months ago. There's a similar case in Maryland, Davis v. State, and it screamed out for this case to be transferred to juvenile court. The prosecutors across the state bemoan Davis v. State because unless the child has already been through the system, they've tried these modalities that are available in the juvenile system, and they failed. Outside of that, almost every juvenile matter is going to be transferred to juvenile court. And when we went back and we looked at the judge's reasoning for not transferring it, it fell far short of what is necessary to deny the request to have a case transferred to juvenile court. So that will go up on appeal, and it's unfortunate that we could not have taken what's called an interlocutory appeal, that we could have not have stopped the process, slowed the trains at that point in time, taken the appeal up to the Court of Appeals, and then had them decide, which we think would have been favorable to us, and then we would have had this matter sent to juvenile court. Okay, we couldn't take an interlocutory appeal. We had to wait until the results of the trial. The trial was over. So once his appellate rights spring into full force and effect, then we will file the appeal, and that will be the major issue that's raised on appeal. And at the same time, we're coming into Judge Schiffer for sentencing, giving her a chance to do the right thing. We think the judge that denied our request earlier did the wrong thing. Now we've got another chance at this thing to have this matter shipped to juvenile court, which is not even possible if he had been found guilty of first-degree murder.
So you consider this a victory, Mr. Brown?
Sorry?
Do we need better self-defense laws in Maryland?
No, because then you're going to get into that old crazy, the stand your ground kind of laws. No, I think the self-defense laws and the defense of other laws are satisfactory. It's just there's different fact patterns that are considered by different juries in deciding whether or not. And in this case, they definitely took advantage of those instructions. That's why he wasn't found guilty of first-degree or second-degree murder. They found that there was some justification for what he did. It was just maybe he overreacted. He didn't need to go that far, but they understood why he did what he did, and it was again justified. There was valid excuse for it, or there was mitigation, and that's why they booted the first and second-degree murder charges and instead rested on the voluntary manslaughter.
Mr. Brown, do you consider this verdict a victory for your side?
Listen, yeah. Oh, absolutely. When you're facing, life imprisonment, and then now you're facing 10 years, and you've got the type of judge that we have, very, very smart judge, well-balanced, fair judge, and you have a person that was 14 at the time of the offense, and the jury has said we kind of understand what he did. That's why we didn't find him guilty of murder 1 or murder 2. And it's the psychologists and psychiatrists who've already written up on him. The state of Maryland Juvenile Services has already done an investigation and said, yes, this young man is good for juvenile system. We definitely feel good, and we're gonna see it through. We're gonna see it through, no question about it.
Thank you, Mr. Brown.
McAlpin, I wondered if you had any comment from the family's perspective and emotionally how their reaction to this.
Yeah, this is clearly a heart-wrenching case on both sides, and our condolences go out to the Reynolds family. There's tension and tears in the courtroom leading up to the verdict. But the family is thankful for the jury's very close review, their extraordinary work throughout this process. This is clearly an emotional case on all parts. So, we're thoughtful of all of that. They're also thankful that the jury did not come back with first degree or second degree murder. And we are thankful for the legal process and the hard work of Mr. Scott's attorney.
So are they satisfied with the outcome?
Well, I think, there's disappointment because they were hoping for an acquittal across the board, considering the facts in the case, and also considering the fact that the prosecution basically provided witnesses that supported the defense. So we're waiting for the legal process to continue. This is not the end of it. And as Mr. Brown stated, there are appellate rights that we will be exercising later on. So the family's disappointed with the voluntary finding, but they're also thankful for the hard work of the jury.
Just for clarity, are you asking for this case to be, like the sentencing to be put into juvenile court, or will it be retried all over
Asking
again?
that the sentence be that he be sentenced to juvenile court, and any disposition that is available in the juvenile system. So, for example, what we are hoping is that after he's been sentenced, the judge will say that, yes, I'm going to go ahead and abide by the recommendations of juvenile services when they prepared that report for the transfer hearing, and that then he will be shipped over to juvenile and required to participate in those programs and be dealt with as a juvenile, which I think is right in this case.
Thank you, Mr. Brown.
Is your plan still to, if Judge Shepard does sentence your client to juvenile court, to still appeal?
Yes, that's right, because the benefit of that would be the case would be transferred, this would be overturned, the case would be transferred to juvenile court, which means he can have this expunged from his record, right, once it's in juvenile. But to be sentenced here to juvenile, it still maintains a record for him.
Okay.
So, but the reality of it is that it would be one and the same. For example, if she goes in and sends him to juvenile, and a year later the Court of Appeals says, yes, he should have been sent to juvenile in the first place, so therefore we're overturning this conviction. The sole benefit of that would be that he could have this expunged from his record.
Okay. I know you said the state offered a plea for second degree murder.
Yes.
Did they attach a specific sentence?
No, but there was a plea to second degree murder. They could, argue for what they wanted, up to 40 years for second degree, and we would be able to argue for juvenile, and the judge would decide what to do, somewhere in between, right? But that wasn't seriously considered because we never considered this to be a murder case. At worst, we thought it would be a manslaughter case, and so we weren't inclined to accept a plea to a murder case when we didn't think that the evidence would sustain a murder conviction.
Juvenile court would have jurisdiction until your client turns 21.
That's correct.
Okay.
That's right.
Sorry, Rebecca.
I thought that the state did offer him a manslaughter plea.
No.
Is that incorrect?
No, they did not. Never, ever. They offered second degree murder, and they weren't giving us anything by saying that you can argue for a transfer to juvenile court. So that's why it was a non-starter, actually.
Can you explain again? So how would this be expunged from his record?
No, if it's reversed on appeal,
Yes.
and the case goes to juvenile court because it's been reversed on appeal, then it can be expunged from his record.
Can or it
Can.
will?
No, it would be. I mean, we would. Yeah, it would be. We would do that. Yes,
What would
legally
the
we could do
process-
that.
what would the process of
Filing the
that be?
paperwork. It ain't that. It's not that difficult. It's like filing paperwork says, hey, this case was overturned on appeal. So therefore we want this expunged from his record, and it would happen. It's just a matter of filing paperwork. No big deal.
Would that be overturning Judge Dorsey?
That's
then?
right. Absolutely. The appeal is meant to overturn Judge Dorsey.
Okay.
That's right. Very astute.
Gotcha.
Right. Exactly. All right, ladies and gentlemen, boys and girls.
Okay, wait. I'm just so
All right.
confused. Off
Call
camera.
me.
Okay.
Call me.
Thank you. Once again, Warren Brown, attorney, he gave a breakdown. He gave a breakdown on manslaughter, 10 years. So trying to get it back into juvenile, and he is 16, 17, 18, 19, 21. So if he gets back in juvenile, they'll hold you to 21, and that'd be 4 years in juvenile. But if they do a whole appeal, and then they can
Hey Dylan,
check it back out.
did
So.
he say like 30 days? I just